Hi everyone, my name's Gemma and I'm an associate in the employment law team at Wright Hassel. Today I'm just going to go over some common questions that we get in relation to contracts of employment. Since April 2020, employers have been required to give employees their written statement of terms since day one of their employment, and that's commonly done as a contract of employment. So it's important that this is right and aligns with the legislation in place and best practice to cover off the employment relationship. So generally, a contract of employment can be signed as a simple contract just by the employee and someone on behalf of the company. However, there are situations where it may need to be signed as a deed, and this occurs where there might be an intellectual property clause included within the contract. So an intellectual property clause, in essence, makes sure that inventions made by the employee during the course of their employment remain the property of the company. So it's in there to protect the company and any inventions that are made within their business. And if that clause is included, depending on the drafting of the clause, there's sometimes a power of attorney included within that to make sure that if the employee does invent anything, that they give the company the power of attorney to sign over any inventions to the company on their behalf if ever required. So if that power of attorney is included, the contract has to be signed as a deed, which means both parties' signatures have to be witnessed at the end of the contract. So if an employer wants to have the opportunity to recoup training costs that they may have paid on behalf of an employee to undertake a training course during their employment, they should have a clear agreement in writing in advance of the training course taking place, which is clear on what costs might need to be repaid and when they might need to be repaid by the employee. Usually, the easiest way to do this is to put a training cost clause in the contract of employment, because that's then agreed at the outset of any employment relationship. And what that clause would usually cover is where training courses are undertaken by an employee that aren't mandatory within the business that the employer requires, but they're courses that an employee wants to undertake and an employer agrees to cover the cost of that on behalf of the employee. Essentially, that course will give the employee some extra expertise or knowledge or potentially a qualification, and therefore there will be a benefit to the business, which is why they'll often pay the cost of the course. But in the event that the employee leaves the business within a set period of time after undertaking that course, the employer may want to recoup some of that cost because they won't get as much of the benefit. And in that situation, the training cost clause may be relied upon. Usually, what the clause would cover is the fact that there will be a percentage of the costs recouped by the company for a set period of time, and the percentage of costs being recouped would decrease over a period of time. So after a few months or a few years, there will be no costs to be repaid because the employer will have benefited from that course being undertaken. So the starting point for looking at a payment in lieu of notice is whether there is a contractual right for an employer to exercise their discretion to do so. So again, we'd be looking at putting a pile-on clause in the contract of employment to cover off that the company has the ability to exercise discretion to ask an employee to not work their notice, and instead they'd receive a payment in lieu of that period. Otherwise, the default position is that an employee would work their contractual notice period. When looking at the pay, again, it's important to see what the wording is in the contract. So if an employer wanted to limit the pay during a notice period, then what they can do is cover off that if a payment in lieu of notice is paid, this is limited to basic pay. And what needs to be then very clear is that will not include any benefits that the employee may otherwise be entitled to had they worked their notice period, such as a bonus or commission. It won't cover the fact that they will accrue extra holiday during their notice period as well. So again, it's important that the contract clearly states that at the outset of the relationship, and in that event, it can be that a payment in lieu of notice is based on basic pay rather than usual pay. So a contract is hopefully normally in written form and signed by both parties, and that shows clear intent from both parties to enter into the terms of that contract. However, that's not always the case. And what can happen is terms of the employment relationship can be agreed verbally, or they can also be impliedly agreed through actions. Now, it's a lot more difficult to determine necessarily what the contractual clauses are if they're not written down. But what would have to happen in those situations is the reality of the situation would need to be considered and see what the intent from both parties is. So in the event you have a contract that isn't signed, if in reality both parties have continued to act in accordance with those terms, and especially if that's been for a significant period of time, it's likely to be found that those terms written down, even though not signed, are contractually binding on both parties. So they're just some of the key questions that we get asked on a regular basis in relation to contracts of employment. If there are any other questions that you have or any other topics that you'd like us to cover in these short clips, please do get in touch and we'll be happy to cover them off for you.